The Trump assassin loses. Judge Cannon came out with this order. You remember her from the classified documents case where Jack Smith was creating a fiction in her courtroom, and she said, "You're not a real boy, Jack. You're not even legitimate. Get out of here." Dismissed that case rightfully. But we're back in her courtroom, and this, of course, is Ryan Ruth, the attempted Trump assassin out at the golf course, who filed a motion to dismiss some charges in his case. And he makes an interesting argument based on the Second Amendment, right? And how the law criminalizes felons for being in possession of firearms if they are convicted felons. And he makes a Second Amendment argument here, saying the Second Amendment provides that a well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms, shall not be infringed. And we are a big fan of that amendment, number 2 there, and makes the argument that these two counts 4 and 5 of the indictment, which are making it illegal for him to be in possession of the weaponry that he was in possession of because he had prior felony convictions. He says those should be dismissed. Judge Cannon didn't buy it. But his argument is a good one if you're a Second Amendment person, because there are questions about the common practice back at the time. Like if you were a convicted felon back during the founding era, were you prohibited from possessing a firearm? Was that a real thing back then? He says, no, it's not. And he goes through, he says, you have to go through an analysis, right? Does the Constitution protect the conduct? If it does, the government must justify the regulation by discussing the nation's historical tradition of firearm regulation. And he says there is no history of firearm regulation in this manner. And he says the government has to prove this. They have not proven that. He says the government showed that the historical tradition here is not satisfied. The problem of felon gun violence that's now addressed in the law was not a historical tradition in the true sense of the meaning. That back during the founding era, there was not a general prohibition that would apply in the same manner here. The lack of any long-standing tradition in this country of permanently disarming felons may be explicable by the fact that at the founding, felons, unlike many other classes of citizens in the country, were not exempt from the militia service. He's saying, actually, back then, there's the Federal Militia Act. Militia members, they were not only simply permitted to possess arms, they were required to purchase and possess arms. And even people who were convicted back then, he says, could possess firearms, right? So therefore, anything that is criminalizing me, Ryan Ruth, as being a felon in possession of a firearm is not in line with the historical tradition of gun regulation and therefore unconstitutional.